This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. There's a very interesting order that I haven't read, and we're going to read together. This is a temporary restraining order issued by Judge R. Brooke Jackson, so not Amy Berman Jackson, but R. Brooke Jackson, out of the District of Colorado, and it's against the city of Denver. Let's see what's going on here. This matter is before the court on plaintiffs' request for a temporary restraining order to enjoin the city and the county, specifically the police department and officers, from using chemical gas agents or physical force against individuals engaged in demonstration activities, documentation of the demonstration of police activities, or the treatment of injured demonstrators. She's going to grant the motion in part, which is remarkable. So what's going on here? It's a temporary restraining order, which is the way federal courts issue injunctions. Temporary for 14 days or less, preliminary after the temporary for the duration of the litigation, and then permanent, which is after the litigation. It is a court order, so it carries more weight. It has teeth. It has more consequences if you disobey it. Whereas a law means that the prosecutor has to bring charges and then you have to have a trial. A court order is within the powers of the court, and anybody who violates it can be hauled before the court, and the very same court can have a hearing right away and figure out what's going on. On May 28th, 2020, citizens of Denver, Colorado joined a nationwide expression of outrage at the death of George Floyd and other acts of violence perpetuated by police officers against the African American community. Though much of the demonstrations have remained peaceful, violence and destruction has occurred at the hands of citizens and police officers alike. Plaintiffs challenged the Denver Police Department, DPD, with their use of chemical agents including mace, oleoresin, capsicum spray, or mist pepper spray, pepper gas, tear gas, skunk, inert smoke, pepper pellets, or xylyl bromide, and or projectiles on protesters participating in these demonstrations. Plaintiffs sue on behalf of themselves and similarly situated individuals, so kind of like a class action, alleging that during these demonstrations, the Denver police have in some instances violated their First Amendment right to free speech and their Fourth Amendment right against excessive force by using pepper spray, pepper balls, rubber bullets, flashbang grenades, and tear gas to punish plaintiffs for demonstrating against police brutality. The court has reviewed video evidence of numerous incidents in which officers used pepper spray on individual demonstrators who appeared to be standing peacefully, some of whom were speaking to or yelling at the officers, none of whom appeared to be engaging in violence or destructive behavior. Plaintiffs cite video evidence of officers using projectiles on several journalists in the process of documenting the scene. Plaintiffs cite video evidence in which a projectile struck and knocked out a peaceful protester. After a medic protester attempts to rescue the unconscious protester, the medic is subsequently shot with projectiles. Plaintiffs further cite video evidence of 4 incidents in which police projectiles struck the eyes of peaceful demonstrators, in some cases resulting in facial fractures, in some cases resulting in permanent loss of vision. Finally, plaintiffs cite video evidence of 3 incidents in which officers threw tear gas or shot pepper balls into peaceful crowds. Plaintiffs allege that defendants' use of such force has resulted in injuries including loss of vision, fractured bones requiring surgery, deep lacerations, loss of eyes, ruptured testicles. They further allege that officers have targeted peaceful protesters, journalists, and protest medics, and have retaliated against demonstrators for engaging in demonstrations, and sometimes for expressing anti-law enforcement sentiment. Plaintiffs allege that this use of force against peaceful protesters and others is sometimes intentional, and that officers target projectiles at demonstrators' heads and groins. Plaintiffs filed a complaint in the Denver District Court June 4th, and they seek relief under 2 causes of action premised on the Civil Rights Act, 42 U.S.C. 1983. They allege that their Fourth Amendment right against excessive force is violated and their First Amendment right to free speech and assembly. The court heard an emergency oral argument motion for a TRO June 5th at 6 p.m. So that's Friday night at 6 p.m. In determining whether to grant a TRO, the court considers the following factors: whether the movement has a substantial likelihood of success on the merits, whether irreparable harm will ensue if denied, whether the injury outweighs the harm that the TRO may cause to the opposing party, the defendant, whether the TRO will affect the public interest, and how. In cases in which the deprivation of constitutional rights is at issue, the likelihood of the success on the merits is determinative, and you can thank Hobby Lobby for establishing that the likelihood of success on the merits is the determinative First Amendment factor. Before turning to those issues, though, I wish to make certain things perfectly clear. Okay, so when the judge starts talking to you in the first person, something's up, and you listen carefully. Before turning to these issues, however, I wish to make certain things perfectly clear, as I did during the hearing held earlier this evening. First, people have an absolute right to demonstrate and protest the actions of government officials, including police officers. It is one of the many freedoms on which this country was built. Second, the police have a very difficult and often thankless job. They frequently are called upon to make split-second decisions and to expose themselves to danger while protecting the health and safety of the rest of us. Third, some of the behaviors of what I hope and believe to be a minority of the police officers in Denver and the nation during the recent days and before, not only vis-a-vis persons of color, but also against peaceful protesters of all backgrounds, have been disgusting. Finally, as I emphasized during the hearing, the difficulty is in trying to draw an enforceable line that permits police officers to use appropriate means to respond to violence and destruction of property without crossing the line into the chilling of free speech and abusing of those who wish to exercise it. I analyzed the likelihood of success of each of plaintiffs' two claims. The Fourth Amendment guarantees a right to be free from excessive force. Excessive force claims are analyzed under the objective reasonableness standard of the Fourth Amendment. The reasonableness of an officer's conduct must be assessed from the perspective of a reasonable officer on the scene. Recognizing the fact that an officer may be forced to make split-second judgments under stressful and dangerous conditions. The Fourth Amendment standard requires inquiry into the factual circumstances of every case. Relevant factors include the severity of the crime, the potential threat posed by the suspect to the officer and the other's safety, and the suspect's attempts to resist or evade arrest. Here, plaintiffs provide video evidence of police conduct at the demonstrations. Those videos show that officers had ample time for reflection and were not dealing with dangerous conditions. Named plaintiffs were attacked with rubber bullets, tear gas, etc., allegedly solely on the basis of their presence at the demonstrations, their viewpoint, or their attempts to render treatment to injured protesters. Additionally, plaintiffs allege that officers specifically aimed at heads and groins, causing broken facial bones and ruptured testicles. These are peaceful demonstrators, journalists, and medics who have been targeted with extreme tactics meant to suppress riots, not to suppress demonstrations. There may later be questions of qualified immunity to grapple with, but plaintiffs have established a strong likelihood that defendants engaged in excessive force contrary to the Fourth Amendment. On the First Amendment claim, the First Amendment provides that all citizens shall have a right to hold and express their personal political beliefs. Organized political protest is a form of classically political speech. The First Amendment safeguards an individual's right to participate in the public debate through political expression and political association. This reflects a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, and the Supreme Court has consistently commented on the central importance of protecting speech on public issues. Thus, courts may scrutinize carefully any restrictions on public issue picketing. Additionally, the Supreme Court has repeatedly held that police may not interfere with orderly, non-violent protests merely because they disagree with the content of the speech or because they simply fear possible disorder. Indeed, it has long been clearly established that the First Amendment bars retaliation for protected speech and association, so these cops are risking a qualified immunity lawsuit. In other words, a lawsuit directly against the personal police officer in their individual capacity and not against the police officer through the police department, where the police department would pay the fine or pay the award. Instead, the police officer themselves would be responsible for the award, plus the police department if they're also included. The 10th Circuit examines First Amendment retaliation claims under Worrell v. Henry, a 10th Circuit year 2000 case which requires inquiry into whether 1. Plaintiffs were engaged in constitutionally protected activity, and 2. Defendants caused the plaintiff to suffer an injury that would chill a person of ordinary firmness from continuing to engage in that activity, and 3. Defendants' actions were motivated by plaintiffs' political activity. Here, first, Plaintiffs were engaged in constitutionally protected activity through organized political protest. Second, defendants' use of excessive force likely caused injury sufficient to chill a person of ordinary firmness from continuing to engage in that political protest. Officers used physical weapons and chemical agents to prevent not just peaceful demonstration, but also the media's ability to document the demonstrations, and plaintiffs and third parties' ability to offer aid to demonstrators. Peaceful demonstrators' legitimate and credible fear of police retaliation is silencing their political speech, the very speech most highly valued under the First Amendment. Third, it also seems likely that defendants' actions were motivated by the content of plaintiffs' demonstrations against police violence. Citizens should never have to fear peaceful protest on the basis of police retaliation, especially not when protesting that very same police violence. As with plaintiffs' Fourth Amendment claims, there may later be questions of qualified immunity. For now, I find that plaintiffs have established a strong likelihood that defendant violated plaintiffs' First Amendment right to free speech. On the irreparable harm factor, the Supreme Court has made clear that the loss of First Amendment freedoms for even minimal periods of time unquestionably constitutes irreparable injury. The demonstrations in Denver are ongoing, likely even as this opinion is written. The demonstrations will likely continue tonight and at least into the weekend. If immediate relief is not granted, plaintiff's speech would be chilled and outright denied over the next several days or weeks of demonstrations. Indeed, irreparable harm has already occurred in the form of physical injury and the suppression of speech. There is no reason such harm would not otherwise continue if this relief were denied. Officers would continue to use force, secure in the knowledge that retrospective claims take a significant amount of time, effort, and money to pursue. Significantly, plaintiffs also note that their speech is deeply rooted in the current time and context. I recognize the importance of shielding and uplifting this ongoing nationwide movement. As such, I find that irreparable harm would occur were I to deny this relief. Balancing of the harm to the non-moving party, plaintiff's motion does not discuss potential harm to the defendant. In theory, the inability to use the complained of tactics limit the officer's ability to protect themselves against potential violence from demonstrators, yet this is a hypothetical harm, especially given the fact that officers have access to many other types of non-lethal weapons that they use on a daily basis, including tasers. The unlikelihood of such harm to officers is outweighed by the very real harm that has already been caused to plaintiffs. Then on the public interest factor, the 10th Circuit has recognized that it is always in the public interest to prevent the violation of a party's constitutional rights. Again, thank you to Hobby Lobby versus Sebelius. The 10th Circuit has particularly recognized a strong public interest in protecting First Amendment values, even where individuals' constitutional rights come into conflict with other important values or public objectives. The 10th Circuit has held that those other values must yield to the protection of individuals. For example, in Awad v. Ziriax, the 10th Circuit noted that while the public has an interest in the will of the voters being carried out, the public has more a profound and long-term interest in upholding an individual's constitutional rights. Here, it is clearly in the public interest to protect plaintiffs' right to demonstrate, the media's ability to document that demonstration, and third parties' ability to render aid to demonstrators without threat of excessive force by police. Plaintiffs' lawsuit is itself a class action on behalf of all similarly situated demonstrators and citizens of Denver whose constitutional rights have been and continue to be violated by the Denver Police Department. Plaintiffs do not expressly discuss the potential harm to the public interest. The most likely potential harm is an increase in property damage. Although I do not agree with those who have committed property damage during the protests, property damage is a small price to pay for constitutional rights, especially the constitutional right of the public to speak against widespread injustice. If a store's windows must be broken to prevent a protester's facial bones from being broken or eye from being permanently damaged, that is more than a fair trade. If a building must be graffitied to prevent the suppression of free speech, that is a fair trade. The threat to physical safety and free speech outweighs the threat to property. Conclusion. In issuing this relief, I do not seek to prevent officers from protecting themselves or their community. I seek to balance citizens' constitutional rights against officers' ability to do their job. However, the time is past to rely solely on the good faith and discretion of the Denver Police Department and its colleagues from other jurisdictions. I believe in everything that Commander Phelan has testified during tonight's hearing about the duty of a police officer to protect the rights of citizens who demonstrate and protest. However, the Denver Police Department has failed in its duty to police its own. Plaintiff's motion for a temporary restraining order is granted in part. The court temporarily enjoins the city and county of Denver Denver, and specifically the police department and officers from other jurisdictions who are assisting, from employing chemical weapons or projectiles of any kind against persons engaging in peaceful protests or demonstrations. To be better assured that this idealistic order is carried out, the court temporarily enjoins the police department and officers from using chemical weapons or projectiles unless an on-scene supervisor at the rank of captain or above specifically authorizes such use of force in response to specific acts of violence or destruction of property that the commanding officer has personally witnessed. The court further orders that kinetic impact projectiles and all other non or less lethal projectiles may never be discharged to the target of the head, pelvis, or back. Kips and all other non or less lethal projectiles shall not be shot indiscriminately into a crowd. Non-Denver officers shall not use any demonstration of force or weapon beyond what Denver itself authorizes. Any non-Denver officer permitted to or directed to be deployed to the demonstration shall be considered an agent of Denver for the purposes of the use of force limitations and this order. All officers deployed to the demonstrations or engaged in the demonstrations must have their body-worn cameras recording at all times, and they may not intentionally obstruct the camera or recording. Chemical agents or irritants, including pepper spray or tear gas, may only be used after an order to disperse is issued. So you can still use tear gas and pepper spray, but only after orders to disperse. Any and all orders to disperse must be followed with adequate time for the intended audience to comply, and the officers must leave room for safe egress. Yeah, we've seen that a couple times. We saw it in Columbus and a couple other places. The officers surround the protesters and then don't let them leave before curfew. Columbus surrounded everyone and then only opened up 2 small egress points right before curfew. If it appears that the intended audience was unable to hear the order must be repeated prior to the use of chemical agents or irritants, and that is Judge R. Brooke Jackson with the United States District Court for the District of Colorado. So bravo, Judge Jackson. I think that's a perfectly tempered and measured order that will help prevent harm to peaceful demonstrators while still allowing the police to do their jobs. But you might disagree. So audience, let us know in the comments below what you think of Judge R. Brooke Jackson's order.
In Canada, we call it kettling, when the police surround a group and then they close in order to, and like if you touch a police officer, you get arrested for assault. And so sometimes they just close in until everybody is arrested, or they can close in and stop you from leaving and then arrest you for breaking curfew. So the kettling is in Canada very frowned upon by judges because it goes against all sorts of principles. And it's a way to criminalize protesting when judges are like, no, you're allowed to, where our society specifically has safeguards to be able to protest, and ignoring that, judges will throw out all sorts of arrests. And the problem is that you can have people who are actual, I don't want to use the word troublemakers, but people who are agitators or who have done damage, who maybe should be held accountable for that. And their arrests will also get tossed along with everybody else who is just there exercising their rights.
The judge then has modified the order already as of Saturday at the request of the police department to say that lieutenants could also approve the use of the weapons that she prohibited, the kips. The city argued that it does not have enough captains to safely comply. And now Smuckers says, are we going to cover their response? Sure. What is their response? Okay, so here there's a response from the city and county of Denver asking for a modification. So they are asking to amend the order, and they are going to go over, so they think that the order has been issued very late, and it's hard for them to comply. They just want to address the 2 most troubling aspects of the order. So the first part is the lieutenants. So yes, the judge did modify the order, allowing lieutenants and not just captains to issue the orders. And their next request is to modify that all officers deployed to the demonstrations must have their body-worn cameras on at all times and not intentionally obstruct the cameras. Denver requires the aid of other jurisdictions who might not have body-worn cameras. Not all jurisdictions have body-worn cameras. And the technical difficulties prevent extremely long durations. So there's usually a buffering mode or an event mode, so either on a loop or continuous recording and then it stops. And the batteries don't last forever. So I think Denver is probably asking for, that sounds normal. Those sound like normal things. My camera batteries don't last forever. So the judge could modify the order, and I guess that she did. And if I'll look at the modified order and see if there's anything worth commenting on. Otherwise, we'll leave it at that. So that's our show, everyone. Thank you for joining me. Let me know what you think in the comments below. I'm Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite legal news and education channel. This is a community-supported channel, meaning we need your financial support. Thank you to the following monthly supporters on patreon.com/ljfrench and sponsors.com/law, and YouTube memberships and Floatplane members. At the $50 plus support level, thank you to Joe Tyson, Wes Delj, Citizen of the Sovereign, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Jan Negrey, Michael Pearce, Daniel Perez, Blackleaf, Benjamin Hitov, Stephen, Ottah, Cute Grills in Your Area, Longreach Jones, Definitely Not Prenda Law, Ugly Grill, Shielo T, Josh Baker, Gregory, Rudolph Bescherer Jr., Kristian, Hellman, Jay Dixon, Ameknight, and Oscar the Phrophet. And thank you to the $5 plus supporters who are scrolling on that LED panel behind me, and everyone will be in the description of the videos that drop. I love you all. I will see you later in the videos that drop. Bye.